Page 1. The Nature and Development of International Law. In the long march of mankind from the cave to the computer, a central role has always been played by the idea of law. The idea that order is necessary and chaos inimical to a just and stable existence. Every society, whether it be large or small, powerful or weak, is created for itself a framework of principles within which to develop. What can be done, what cannot be done, permissible acts, forbidden acts, have all been spelt out within the consciousness of that community. Progress, with its inexplicable leaps and bounds, has always been based upon the group as men and women combine to pursue commonly accepted goals, whether these be hunting animals, growing food, or simply making money. Law is that element which binds the members of the community together in their adherence to recognized values and standards. It is both permissive in allowing individuals to establish their own legal relations with rights and duties, as in the creation of contracts, and coercive, as it punishes those who infringe its regulations. Law consists of a series of rules regulating behavior and reflecting, to some extent, the ideas and preoccupations of the society within which it functions. And so it is with what is termed international law, with the important difference that the principal subjects of international law are nation-states, not individual citizens. There are many contrasts between the law within a country, municipal law, and the law that operates outside and between states, international organizations, and, in certain cases, individuals. International law itself is divided into conflict laws, or private international law, as it is sometimes called, and public international law, usually just termed international law. The former deals with those cases within particular legal systems in which foreign elements obtrude, raising questions as to the application of foreign law or the role of foreign courts. Page 2. For example, if two Englishmen make a contract in France to sell goods situated in Paris, an English court would apply French laws as regards to the validity of that contract. By contrast, public international law is not simply an adjunct of legal order, but a separate system altogether, and it is this field that will be considered in this book. Public international law covers relations between states in all their myriad forms, from war to satellites, and regulates the operations of the many international institutions. It may be universal or general, in which case the stipulated rules bind all the states, or practically all, depending on the nature of the rule, or regional, whereby a group of states linked geographically or ideologically may recognize special rules applying only to them. For example, the practice of diplomatic asylum that has developed to its greatest extent in Latin America. The rules of international law must be distinguished from what is called international comity, or practices such as saluting the flags of foreign warships at sea, which are implemented solely through courtesy and are not regarded as legally binding. Similarly, the mistake of confusing international law with international morality must be avoided. While they may meet at certain points, the former discipline is a legal one, both as regards its content and its form, while the concept of international morality is a branch of ethics. This does not mean, however, that international law can be divorced from its values. In this chapter and the next, the characteristics of the international legal system and the historical and theoretical background necessary to a proper appreciation of the part to be played by the law in international law will be examined. Law and politics in the world community. It is the legal quality of international law that is the first question to be posed. Each side to an international dispute will doubtless claim legal justification for its actions, and within the legal international system there is no independent institution able to determine the issue and give a final decision. Virtually everybody who starts reading about international law does so having learned or absorbed something about the principal characteristics of ordinary or domestic law. Such identifying marks would include the Page 3. Existence of a recognized body to legislate or create laws, a hierarchy of courts with compulsory jurisdiction to settle disputes over such laws, and an accepted system of enforcing those laws. Without the legislature, judiciary, and executive, it would seem that one cannot talk about a legal order, and international law does not fit this model. International law has no legislature. The General Assembly of the United Nations, comprising delegates from all the member states, exists, but its resolutions are not legally binding save for certain of the organs of the United Nations for certain purposes. There is no system of courts. The International Court of Justice does exist at The Hague, but it can only decide cases when both sides agree, and it cannot ensure that its decisions are complied with. Above all, there is no executive or governing entity. The Security Council of the United Nations, which was intended to have such a role in a sense, has at times been effectively constrained by the veto power of the 5 permanent members: USA, USSR, now the Russian Federation, China, France, and the United Kingdom. Thus, if there is no identifiable institution either to establish rules, or to clarify them, or to see that those who break them are punished, how can what is called international law be law? It will, of course, be realized that the basis for this line of argument is the comparison of domestic law with international law, and the assumption of an analogy between the national system and the international order. And this is at the heart of all discussions about the nature of international law. At the turn of the 19th century, the English philosopher John Austin elaborated a theory of law based upon the notion of a sovereign issuing a command backed by a sanction or punishment. Since international law did not fit within that definition, it was relegated to the category of positive morality. This concept has been criticized for oversimplifying and even confusing the true nature of law within a society, and for even overemphasizing the role of the sanction within the system by linking it to every rule. This is not the place for a comprehensive summary of Austin's, page 4, theory, but the idea of coercion as an integral part of any legal order is a vital one that needs looking at in the context of international law. The role of force. There is no unified system of sanctions in international law, in the sense that there is in municipal law, but there are circumstances in which the use of force is regarded as justified and legal. Within the United Nations systems, sanctions may be imposed by the Security Council upon the determination of a threat to the peace, breach of the peace, or act of aggression. Such sanctions may be economic, for example those proclaimed in 1966 against Rhodesia, or military, as in the Korean War in 1950, or indeed both, as in 1990 against Iraq. Coercive action within the framework of the UN is rare because it requires coordination amongst the 5 permanent members of the Security Council, and this obviously needs an issue not regarded by any of the great powers as a threat to their vital interests. Korea was an exception, and joint action could only be undertaken because of the fortuitous absence of the USSR from the Council, as a protest at the seating of the nationalist Chinese representatives. Apart from such institutional sanctions, one may note the bundle of rights to take violent action known as self-help. This procedure to resort to force to defend certain rights is characteristic of primitive systems of law with blood feuds, but in the domestic legal order, such procedures and, page 5, methods are now within the exclusive control of the established authority. States may use force in self-defense if the object of aggression, and may take action in response to the illegal acts of other states. In such cases, the states themselves decide whether to take action and, if so, the extent of their measures, and there is no supreme body to rule on their legality or otherwise. In the absence of an examination by the International Court of Justice, acceptable to both parties, although international law does not lay down relevant rules. Accordingly, those writers who put the element of force to the forefront of their theories face many difficulties in describing the nature, or rather legal nature, of international law, with its lack of a coherent, recognized, and comprehensive framework of sanctions. To see the sanctions of international law in the states' right of self-defense and reprisals is to misunderstand the role of sanctions within a system because they are at the disposal of the states, not the system itself. Neither must it be forgotten that the current trend in international law is to restrict the use of force as far as possible, thus leading to the absurd result that the more force is controlled in international society, the less legal international law becomes, since one cannot discover the nature of international law by reference to a definition of law predicated upon sanctions. The character of the international legal order has to be examined in order to seek to discover whether in fact states feel obliged to obey the rules of international law and, if so, why. If, indeed, the answer to the first question is negative, that states do not feel the necessity to act in accordance with such rules, then there does not exist any system of international law worthy of the name. The international system. The key to the search lies within the unique attributes of the international system, in the sense of the network of relationships existing primarily, if not exclusively, between states recognizing certain common principles, page 6, and ways of doing things. While the legal structure within all but the most primitive societies is hierarchical and authority is vertical, the international system is horizontal, consisting of over 190 independent states, all equal in legal theory, in that they all possess the characteristics of sovereignty, and recognizing no one in authority over them. The law is above individuals in domestic systems, But international law only exists as between the states. Individuals only have the choice as to whether to obey the law or not. They do not create the law. That is done by specific institutions. In international law, on the other hand, it is the states themselves that create the law and obey it or disobey it. This, of course, has profound repercussions as regards to the sources of law, as well as the means for enforcing accepted legal rules. International law, as will be shown in succeeding chapters, is primarily formulated by international agreements, which create rules binding upon the signatories, and customary rules, which are basically state practices recognized by the community at large as laying down patterns of conduct that have to be complied with. However, it may be argued that since states themselves sign treaties and engage in action that they may or may not regard as legally obligatory, international law would appear to consist of a series of rules from which states may pick and choose. Contrary to popular belief, states do observe international law, and violations are comparatively rare. However, such violations, like armed attacks and racial oppression, are well publicized and strike at the heart of the system, the creation and preservation of international peace and justice. But just as incidents of murder, robbery and rape do occur within national legal orders without destroying the system as such, so, analogously, assaults upon international legal rules point up the weaknesses of the system without denigrating their validity or their necessity. Thus, despite the occasional gross violation, the vast majority of the provisions of international law are followed. Page 7. In the daily routine of international life, large numbers of agreements and customs are complied with. However, the need is felt in the hectic interplay of world affairs for some kind of regulatory framework or rules network within which the game can be played, and international law fulfills that requirement. States feel this necessity because it imports an element of stability and predictability into the situation. Where countries are involved in a disagreement or a dispute, it is handy to have recourse to the rules of international law, even if there are conflicting interpretations, since at least there is a common frame of reference and one state will be aware of how the other state will develop its argument. They will both be talking a common language, and this factor of communication is vital since misunderstandings occur so easily and often with tragic consequences. Where the antagonists dispute the understanding of a particular rule and adopt opposing stands as regards to its implementation, they are at least on the same wavelength and communicate by means of the same phrases. That is something. It is not everything, for it is a mistake, as well as inaccurate, to claim for international law more than it could possibly deliver. It can constitute a mutually understandable vocabulary book and suggest possible solutions which follow from a study of its principles. What it cannot do is solve every problem, no matter how dangerous or complex, merely by being there. International law has not yet been developed, if it ever will, to that particular stage, and one should not exaggerate its capabilities while pointing to its positive features. But what is to stop a state from simply ignoring international law and proceeding upon its chosen policy? Can a legal rule against aggression, for example, of itself prevail over political temptations? There is no international police force to prevent such an action, but there are a series of other considerations closely bound up with the character of international law, which might well cause a potential aggressor to forbear. There is the element of reciprocity at work, and a powerful weapon it can be. States quite often do not pursue one particular course of action which might bring them short-term gains, because it could disrupt the mesh of reciprocal tolerance, which could very well bring long-term disadvantages. For example, states everywhere protect the immunity of foreign diplomats, for not to do so would place their own officials abroad at risk. This constitutes an inducement to states to act reasonably and moderate. Page 8. Demands in the expectation that this will similarly encourage other states to act reasonably and so avoid confrontations. Because the rules can ultimately be changed by states altering their patterns of behavior and causing one custom to supersede another, or by mutual agreement, a certain definite reference to political life is retained. But the point must be made that a state, after weighing up all possible alternatives, might very well feel that the only method to protect its vital interests would involve a violation of international law, and that responsibility would just have to be taken. Where survival is involved, international law may take second place. Another significant factor is the advantages or rewards that may occur in certain situations from an observance of international law. It may encourage friendly or neutral states to side with one country involved in a conflict rather than its opponent, and even take a more active role than might otherwise have been the case. In many ways, it is an appeal to public opinion for support, and all states employ this tactic. In many ways, it reflects the esteem in which law is held. The Soviet Union made considerable use of legal arguments in its effort to establish its non-liability to contribute towards the peacekeeping operations of the United Nations, and the Americans too justify their activities with regard to Cuba and Vietnam by reference to international law. In some cases it may work, and bring considerable support in its wake. In many cases it will not. But in any event, the very fact that all states do it is a constructive sign. A further element worth mentioning in this context is the constant formulation of international business in characteristically legal terms. Points of view and disputes, in particular, are framed legally, with references to precedent, international agreements, and even to opinions of juristic authors. Claims are pursued with regard to the rules of international law, and not in terms of, for example, morality or ethics. This is brought into being a class of officials throughout governmental departments in page 9, addition to those working in international institutions, versed in international law, and carrying on the everyday functions of government in a law-oriented way. Many writers have, in fact, emphasized the role of officials in the actual functioning of law, and the influence they have upon the legal process. Having come to the conclusion that states do observe international law, and will usually only violate it on an issue regarded as vital to their interests, the question arises as to the basis of this sense of obligation. The 19th century, with its business-oriented philosophy, stressed the importance of the contract as the legal basis of an agreement freely entered into by both or all sides, and this influenced the theory of consent in international law. States were independent and free agents, and accordingly they could only be bound with their own consent. There was no authority in existence able to theoretically or practically to impose rules upon the various nation-states. This approach found its extreme expression in the theory of auto-limitation or self-limitation, which declared that states could only be obliged to comply with international legal rules if they had first agreed so to be obliged. Nevertheless, this theory is most unsatisfactory as an account of why international law is regarded as binding, or even as an explanation of the international legal system. To give one example, there are about 100 states that have come into existence since the end of the Second World War, and by no stretch of the imagination can it be said that such states have consented to all the rules of international law formed prior to their establishment. It could be argued that by accepting independence, states consent to all existing rules, but to take this view relegates consent to the role of a mere fiction. Page 10. This theory also fails as an adequate explanation of the international legal system, because it does not take into account the tremendous growth in international institutions and the network of rules and regulations that have emerged from within the last generation. To accept consent as the basis for obligation in international law begs the question as to what happens when consent is withdrawn. The state's reversal of its agreement to a rule does not render that rule optional, or remove from it its aura of legality. It merely places that state in breach of its obligations under international law if that state proceeds to act upon its decision. Indeed, the principle that agreements are binding, pacta sunt servanda, upon which all treaty law must be based, cannot itself be based upon consent. One current approach to this problem is to refer to the doctrine of consensus. This reflects the influence of the majority in creating new norms of international law and the acceptance by other states of such new rules. It attempts to put into focus the change of emphasis that is beginning to take place from exclusive concentration upon the nation-state to a consideration of the developing forms of international cooperation, where such concepts as consent and sanction are inadequate to explain what is happening. Of course, one cannot ignore the role of consent in international law. To recognize its limitations is not to neglect its significance. Much of international law is constituted by states expressly agreeing to specific normative standards, most obviously by entering into treaties. This cannot be minimized. Nevertheless, it is preferable to consider consent as important not only with regard to specific rules specifically accepted, which is not the sum total of international law, of course, but in the light of the approach of states generally to the totality of rules, understandings, patterns of behavior, and structures underpinning and constituting the international system. In a broad sense, states accept or consent to the general system of international law, for in reality, without that no such system could possibly operate. It is this approach which may be characterized as consensus. Page 11. Or the essential framework within which the demand for individual state consent is transmuted into community acceptance. It is important to note that while states from time to time object to particular rules of international law and seek to change them, no state has sought to maintain that it is free to object to the system as a whole. Each individual state, of course, has the right to seek to influence by word or deed the development of specific rules of international law. But the creation of new customary rules is not dependent upon the express consent of each particular state. The function of politics. It is clear that there can never be a complete separation between law and policy. No matter what theory of law or political philosophy is professed, the inextricable bonds linking law and politics must be recognized. Within developed societies, a distinction is made between the formulation of policy and the method of its enforcement. In the United Kingdom, Parliament legislates while the courts adjudicate, and a similar division is maintained in the United States between the Congress and the court system. The purpose of such divisions, of course, is to prevent a concentration of too much power within one branch of government. Nevertheless, it is the political branch which makes laws and in the first place creates the legal system. Even within the hierarchy of courts, the judges have leeway in interpreting the law, and in the last resort make decisions from amongst a number of alternatives. This position, however, should not be exaggerated, because a number of factors operate to conceal and lessen the impact of politics upon the legal process. Foremost among these is the psychological element of tradition and the development of the so-called law habit. A particular legal atmosphere has been created, which is buttressed by the political system and recognizes the independent existence of law institutions and methods of operation characterized as just or legal. In most countries, overt interference with the judicial process would be regarded as an attack upon basic principles and hotly contested. The use of legal language and accepted procedures together with the pride of the legal profession reinforce the system and emphasize the degree, page 12, of distance maintained between the legislative executive organs and the judicial structure. However, when one looks at the international legal scene, the situation changes. The arbiters of the world are, in the last resort, the states, and they both make the rules, ignoring for the moment the secondary, if growing, field of international organizations, and interpret and enforce them. While it is possible to discern an international legal habit amongst governmental and international officials, the machinery necessary to enshrine this does not exist. Politics is much closer to the heart of the system than is perceived within national legal orders, and power much more in evidence. The interplay of law and politics in world affairs is much more complex and difficult to unravel, and signals a return to the earlier discussion as to why states comply with international rules. Power politics stresses competition, conflict, and supremacy, and adopts as its core the struggle for survival and influence. International law aims for harmony and the regulation of disputes. It attempts to create a framework, no matter how rudimentary, which can act as a kind of shock absorber, clarifying and moderating claims and endeavoring to balance interests. In addition, it sets out a series of principles declaring how states should behave, just as any domestic community must have a background of ideas and hopes to aim at, even if a few can be or ever attained. So the international community, too, must bear in mind its ultimate values. However, these ultimate values are in a formal sense kept at arm's length from the legal process. As the International Court noted in the Southwest Africa case, it is a court of law and can take account of moral principles only insofar as these are given a sufficient expression in legal form. Law exists, it is said, to serve a social need, but precisely for that reason it can do so only through and within the limits of its own discipline. Otherwise, it is not a legal service that would be rendered. International law cannot be a source of instant solutions to problems of conflict and confrontation because of its own inherent weaknesses. Page 13. In structure and content. To fail to recognize this encourages a utopian approach which, when faced with reality, will fail. On the other hand, the cynical attitude with its obsession with brute power is equally inaccurate, if more depressing. It is the medium road, recognizing the strength and weaknesses of international law and pointing out what it can achieve and what it cannot, which offers the best hope. Man seeks order, welfare, and justice not only within the state in which he lives, but also within the international system in which he lives. Historical development. The foundations of international law or the law of nations, as it is understood today, lie firmly in the development of Western culture and political organization. The growth of European notions of sovereignty and the independent nation-state required an acceptable method whereby interstate relations could be conducted in accordance with commonly accepted standards of. Page 14. Behavior and international law filled the gap. But although the law of nations took root and flowered with the sophistication of Renaissance Europe, the seeds of this particular hybrid plant are of far older lineage. They reach far back into history. Early origins. While the modern international system can be traced back some 400 years, certain of the basic concepts of international law can be discerned in political relationships thousands of years ago. Around 2100 BC, for instance, a solemn treaty was signed between the rulers of Lagash and Umma, the city-states situated in the area known to historians as Mesopotamia. It was inscribed on a stone block and concerned the establishment of a defined boundary to be respected by both sides under pain of alienating a number of Sumerian gods. The next major instance known of an important, binding, international treaty is that concluded over 1,000 years later between Ramses II of Egypt and King of the Hittites for the establishment of eternal peace and brotherhood. Other points covered in that agreement signed, it would seem, at Kadesh, north of Damascus, included respect for each other's territorial integrity, the termination of a state of aggression, and the setting up of a form of defensive alliance. Since that date, many agreements between the rival Middle Eastern powers were concluded, usually aimed at embodying in a ritual form a state of subservience between the parties, or attempting to create a political alliance to contain the influence of an overpowerful empire. Page 15. The role of ancient Israel must also be noted. A universal ethical stance coupled with rules relating to warfare were handed down to other peoples and religions, and the demand for justice and a fair system of law founded upon strict morality permeated the thought and conduct of subsequent generations. For example, the prophet Isaiah declared that sworn agreements, even where made with the enemy, must be performed. Peace and social justice were the keys to man's existence, not power. After much neglect, there is now more consideration of the cultures and standards that evolved before the birth of Christ in the Far East, in the Indian and Chinese civilizations. Many of the Hindu rules displayed a growing sense of morality and generosity, and the Chinese Empire devoted much thought to harmonious relations between its constituent parts. Regulations controlling violence and the behavior of varying factions with regard to innocent civilians were introduced, and ethical issues instilled in the education of the ruling classes. In times of Chinese dominance, a regional tributary state system operated which fragmented somewhat in times of weakness, but this remained culturally alive for many centuries. However, the predominant approach of ancient civilizations was geographically and culturally resisted. There was no conception of an, page 16, international community of states coexisting within a defined framework. The scope for any international law of states was extremely limited, and all that one can point to is the existence of certain ideals, such as the sanctity of treaties, which have continued to this day as important elements in society. But the notion of universal community, with its ideal of world order, was not in evidence. The era of classical Greece from about the 6th century BC and onwards for a couple of hundred years has, one must note, been of overwhelming significance for European thought. Its critical and rational turn of mind, its constant questioning and analysis of man and nature, and its love of argument and debate was spread throughout Europe and the Mediterranean world by the Roman Empire, which adopted Hellenic culture wholesale and penetrated Western consciousness with the Renaissance. However, Greek awareness was limited to their own competitive city-states and colonies. Those of different origin were barbarians not deemed worthy of association. The value of Greece in a study of international law lies partly in the philosophical, scientific, and political analyses bequeathed to mankind, and partly in the fascinating state of interrelationship built up within the Hellenistic world. Numerous treaties linked the city-states together in a network of commercial and political associations. Rights were often granted to the citizens of the states in each other's territories, and rules regarding the sanctity and protection of diplomatic envoys developed. Certain practices were essential before the declaration of war, and the horrors of war were somewhat ameliorated by the exercise, for example, of religious customs regarding sanctuaries, but no overall moral approach similar to those emerging from Jewish and Hindu thought particularly evolved. No sense of a world community can be traced back to Greek ideology, in spite of the growth of Greek colonies throughout the Mediterranean area. This was left to the able administrators of the Roman Empire. The Romans had a profound respect for organization and the law. The law knitted together their empire and constituted a vital source of, page 17, reference for every inhabitant of the far-flung domain. The early Roman law, the jus civile, applied only to Roman citizens. It was formalistic and hard, and reflected the status of a small, unsophisticated society rooted in the soil. It was totally unable to provide a relevant background for an expanding, developing nation. This need was served by the creation and progressive augmentation of the jus gentium. This provided simplified rules to govern the relations between foreigners and citizens. The instrument through which this particular system evolved was the official, known as the praetor peregrinus, whose function it was to oversee all legal relationships, including bureaucratic and commercial matters within the empire. The progressive rules of the jus gentium gradually overrode the narrow jus civile until the latter system ceased to exist. Thus, the jus gentium became the common law of the Roman Empire, and was deemed to be of universal application. It is this all-embracing factor which so strongly distinguishes the Roman from the Greek experience, although, of course, there was no question of the acceptance of other nations on a basis of equality, and the jus gentium remained a national law for the Roman Empire. One of the most influential of Greek concepts taken up by the Romans was the idea of natural law. This was formulated by the Stoic philosophers of the 3rd century BC, and their theory was that it constituted a body of rules of universal relevance. Such rules were rational and logical, and because the ideas and precepts of the law of nature were rooted in human intelligence, it followed that such rules could not be restricted to any nation or any group, but were of worldwide relevance. This element of universality is basic to modern doctrines of international law, and the Stoic elevation of human powers of logical deduction to the supreme pinnacle of discovering the law foreshadows the rational philosophies of the West. In addition to being a fundamental concept in legal theory, natural law is vital to an understanding of international law, as well as being an indispensable precursor to contemporary concern with human rights. Certain Roman philosophers incorporated those Greek ideas of natural law into their own legal theories, often as a kind of ultimate justification, page 18, of the jus gentium, which was deemed to enshrine rational principles common to all civilized nations. However, the law of nature was held to have an existence over and above that of the jus gentium. This led to much confusion over the exact relationship between the two ideas, and different Roman lawyers came to different conclusions as to their identity and characteristics. The important factors, though, that need to be noted are the theories of the universality of law and the rational origins of legal rules that were founded, theoretically at least, not on superior force, but on superior reason. The classical rules of Roman law were collated in the Corpus Juris Civilis, a compilation of legal material by a series of Byzantine philosophers, completed in AD 534. Such a collection was to be invaluable when the darkness of the early Middle Ages, following the Roman collapse, began gradually to evaporate. For here was a body of developed laws ready-made and awaiting transference to an awakening Europe. At this stage, reference must be made to the growth of Islam. Its approach to international relations and law was predicated upon a state of hostility towards the non-Muslim world and the concept of unity, Dar al-Islam, as between Muslim countries. Generally speaking, humane rules of warfare were developed, and the People's Book, Jews and Christians, were treated better than non-believers, although in an inferior position to Muslims. Once the period of conquest was over and power was consolidated, norms governing conduct with non-Muslim states began to develop. The law dealing with diplomats was founded upon notions of hospitality and safety, aman, while rules governing international agreements grew out of the concept of respecting promises made. Page 19. The Middle Ages and the Renaissance. The Middle Ages were characterized by the authority of the organized church and the comprehensive structure of power that it commanded. All of Europe was one religion, and the ecclesiastical law applied to all, notwithstanding tribal or regional affiliations. For much of the period, there were struggles between the religious authorities and the rulers of the Holy Roman Empire. These conflicts were eventually resolved in favor of the papacy, but the victory over secularism proved of relatively short duration. Religion and a common legacy derived from the Roman Empire were strongly unifying influences, while political and regional rivalries were not. But before a recognized system of international law could be created, social changes were essential. Of particular importance during this era were the authority of the Holy Roman Empire and the supranational character of canon law. Nevertheless, commercial and maritime law developed apace. English law established the law merchant, a code of rules covering foreign traders, and this was declared to be of universal application. Throughout Europe, mercantile courts were set up to settle disputes between tradesmen at the various fairs. And while it is not possible to state that a continental law merchant came into being, a network of common regulations and practices weaved its way across the commercial fabric of Europe and constituted an embryonic international trade law. Similarly, maritime customs began to be accepted throughout the continent. Founded upon Rhodian sea law, a Byzantine work, many of whose rules were enshrined in the Rolls of Oleron in the 12th century, and other maritime textbooks. A series of commonly applied customs relating to the sea permeated the naval powers of the Atlantic and Mediterranean coasts. Page 20. Such commercial and maritime codes, while at this stage merely expressions of national legal systems, were amongst the frontrunners of international law because they were created and nurtured against a backcloth of cross-national contacts and reflected the need for rules that would cover international situations. Such rules, growing out of the early Middle Ages, constituted the seeds of international law, but before they could flourish, European thought had first to be developed by that intellectual explosion known as the Renaissance. This complex of ideas changed the face of European society and ushered in the modern era of scientific, humanistic, and individualistic thought. The collapse of the Byzantine Empire centered on Constantinople before the Turkish armies in 1453 drove back Greek scholars to seek sanctuary in Italy and enliven Western Europe's cultural life. The introduction of printing during the 15th century provided the means to disseminate knowledge, and the undermining of feudalism in the wake of economic growth and the rise of the merchant classes provided the background to the new inquiring attitudes taking shape. Europe's developing self-confidence manifested itself in a sustained drive overseas for wealth and luxury items. By the end of the 15th century, the Arabs had been ousted from the Iberian Peninsula and the Americans reached. The rise of the nation-states of England, France, and Spain in particular characterized the process of the creation of territorially consolidated independent units in theory and doctrine as well as in fact. This led to a higher degree of interaction between sovereign entities and thus the need to regulate such activities in a generally acceptable fashion. The pursuit of political power and supremacy became overt and recognized, as Machiavelli's The Prince 1513 demonstrated. The city-states of Italy struggled for supremacy, and the papacy too became a secular power. From these hectic struggles emerged many of the staples of modern international life: diplomacy, statesmanship, the theory of balance of power, and the idea of a community of states. Notions such as these are immediately appreciable, and one can identify with the various maneuvers for political supremacy. Alliances, betrayals, manipulations of state institutions, and the drive for power are not unknown to us. We recognize the roots of our society. Page 21. It was the evolution of the concept of an international community of separate, sovereign, if competing, states that marks the beginning of what is understood by international law. The Renaissance bequeathed the prerequisites of independent, critical thought and humanistic, secular approach to life, as well as the political framework for the future. But it is the latter factor which is vital to the subsequent growth of international law. The Reformation and the European religious wars that followed emphasized this, as did the growing power of the nations. In many ways, these wars marked the decline of a continental system founded on religion and the birth of a continental system founded on the supremacy of the state. Throughout these countries, the necessity was felt for a new conception of humans as well as state relationships. This surge was precipitated, as had been intimated, by the decline of the Church and the rise of what might be termed free thinking. The theory of international law was naturally deeply involved in this reappraisal of political life, and it was tremendously influenced by the rediscovery of Greco-Roman ideas. The Renaissance stimulated a rebirth of Hellenic studies, and ideas of natural law, in particular, became popular. Thus, a distinct value system to underpin international relations was brought into being, and the law of nations was heralded as part of the universal law of nature. With the rise of the modern state and the emancipation of international relations, the doctrine of sovereignty emerged. This concept, first analyzed systematically, in 1576 in the Six Livres de la République by Jean Bodin was intended to deal with the structure of authority within the modern state. Bodin, who based his study upon his perception of the politics of Europe rather than on a theoretical discussion of absolute principles, emphasized the necessity for a sovereign power within the state that would make the laws. While such a sovereign could not be bound by the laws he himself instituted, he was subject to the laws of God and of nature. The idea of the sovereign as supreme legislator was in course of time transmuted into the principle which gave the state supreme power vis-à-vis other states. The state was regarded as being above the law. Such, page 22, notions as these form the intellectual basis of the line of thought known as positivism, which will be discussed later. The early theorists of international law were deeply involved with the ideas of natural law and used them as the basis of their philosophies. Included within that complex of natural law principles from which they constructed their theories was the significant merging of Christian and natural law ideas that occurred in the philosophy of St. Thomas Aquinas. He maintained that natural law formed part of the law of God and was the participation by rational creatures in the eternal law. It complemented that part of the eternal law which had been divinely revealed. Reason, declared Aquinas, was the essence of man and thus must be involved in the ordering of life according to the divine will. Natural law was the fount of moral behavior, as well as of social and political institutions, and it led to the theory of conditional acceptance of authority, with unjust laws being unacceptable. Aquinas' views of the late 13th century can be regarded as basic to an understanding of present Catholic attitudes, but should not be confused with the later interpretation of natural law, which stressed the concepts of natural rights. It is with such an intellectual background that Renaissance scholars approached the question of the basis and justification of a system of international law. Maine, a British historical lawyer, wrote that the birth of modern international law was the grandest function of the law of nature, and while that is arguable, the point must be taken. International law began to emerge as a separate topic to be studied within itself, although derived from the principles of natural law. The founders of modern international law. The essence of the new approach to international law can be traced back to the Spanish philosophers of that country's golden age. The leading figure of this school was Francisco Vitoria, professor of theology at the University of Salamanca, 1450 to 1546. His lectures were preserved by his students and published posthumously. He demonstrated a remarkably progressive attitude for his time towards the Spanish conquest of the, page 23, South American Indians and, contrary to the views prevalent until then, maintained that the Indian people should be regarded as nations with their own legitimate interests. War against them could only be justified on the grounds of a just cause. International law was founded on the universal law of nature, and this meant that non-Europeans must be included within its ambit. However, Vitoria by no means advocated the recognition of the Indian nations as equal to the Christian states of Europe. For him, opposing the work of the missionaries in the territories was a just reason for war, and he adopted a rather extensive view as to the rights of the Spaniards in South America. Vitoria was no liberal, and indeed acted on behalf of the Spanish Inquisition, but his lectures did mark a step forward in the right direction. Suarez, 1548 to 1617, was a Jesuit and professor of theology who was deeply immersed in medieval culture. He noted that the obligatory character of international law was based upon natural law, while its substance derived from the natural law rule of carrying out agreements entered into. From a totally different background, but equally, if not more, influential, was Alberico Gentili, from 1552 to 1608. He was born in northern Italy and fled to England to avoid persecution, having converted to Protestantism. In 1598, his De Jure Belli was published. It is a comprehensive discussion of the law of war and contains a valuable section on the law of treaties. Gentili, who became a professor at Oxford, has been called the originator of the secular school of thought in international law, and he minimized the hitherto significant theological thesis. It is, however, Hugo Grotius, a Dutch scholar, who towers over this period and has been celebrated, if a little exaggeratedly, as the father of international law. He was born in 1583 and was the supreme Renaissance man. A scholar of tremendous learning, he mastered history, theology, mathematics, and the law. His primary work was the De Jure Belli Ac Pacis. Page 24. written during 1623 and 1624. It is an extensive work and includes rather more devotion to the exposition of private law notions than would seem appropriate today. He refers both to Vittoria and Gentili, the latter being of special influence with regard to many matters, particularly organization of material. Grotius finally excised theology from international law and emphasized the irrelevance in such a study of any conception of a divine law. He remarked that the law of nature would be valid even if there were no God, a statement which, although suitably clothed in religious protestation, was extremely daring. The law of nature now reverted to being founded exclusively on reason. Justice was part of man's social makeup, and thus not only useful but essential. Grotius conceived of a comprehensive system of international law, and his work rapidly became a university textbook. However, in many spheres, he followed well-trodden paths. He retained the theological distinction between a just and unjust war, a notion that was soon to disappear from treaties on international law, but which in some way underpins modern approaches to aggression, self-defense, and liberation. One of his most enduring opinions consists in his proclamation of the freedom of the seas. The Dutch scholar opposed the close-seas concept of the Portuguese that was later elucidated by the English writer John Selden, and emphasized instead the principle that the nations could not appropriate to themselves the high seas. They belonged to all. It must, of course, be mentioned, parenthetically, that this theory happened to accord rather nicely with prevailing Dutch ideas as to free trade and the needs of an expanding commercial empire. However, this merely points up what must not be disregarded, namely that concepts of law as politics and other disciplines are firmly rooted in the world of reality and reflect contemporary preoccupations. No theory develops in a vacuum, but is conceived and brought to fruition in a definite cultural and social environment. To ignore this is to distort the theory itself. Page 25. On the one hand, there was the naturalist school, exemplified by Samuel Pufendorf, 1632-94, who attempted to identify international law completely with the law of nature, and on the other hand, there were the exponents of positivism, who distinguished between international law and natural law, and emphasized practical problems and current state practices. Pufendorf regarded natural law as a moralistic system, and misunderstood the direction of modern international law by denying the validity of the rules about custom. He also refused to acknowledge treaties as in any way relevant to a discussion of the basis of international law. Other naturalists echoed those sentiments in minimizing or ignoring the actual practices of states in favor of a theoretical construction of absolute values that seemed slowly to drift away from the complexities of political reality. One of the principal initiators of the positivist school was Richard Zouch, 1590 to 1660, who lived at the same time as Pufendorf, but in England. While completely dismissing natural law, he paid scant regard to the traditional doctrines. His concern was with specific situations, and his book contains many examples from the recent past. He elevated the law of peace above a systematic consideration of the law of war and eschewed theoretical expositions. In similar style, Blenkirshoek, 1673 to 1743, stressed the importance of modern practice and virtually ignored natural law. He made great contributions to the developing theories of the rights and duties of neutrals in war, and after careful studies of the relevant facts, decided in favor of the freedom of the seas. The positivist approach, like much modern thought, was derived from the empirical method adopted by the Renaissance. It was concerned not with an edifice of theory structured upon deductions from absolute principles, but rather with viewing events as they occurred and discussing actual problems that had arisen. Empiricism, as formulated by Locke and Hume, denied the existence of innate principles and postulated that ideas were derived from experience. The scientific method of experiment and verification of hypotheses emphasized this approach. From this philosophical attitude, it was a short step to reinterpreting international law, not in terms of concepts derived from reason, but rather in terms of what actually happened between the competing states. What, page 26, states actually do was the key, not what states ought to do, given basic rules of the law of nature. Agreements and customs recognized by the states were the essence of the law of nations. Positivism developed as the modern nation-state system emerged out of the Peace of Westphalia in 1648 from the religious wars. It coincided, too, with theories of sovereignty, such as those propounded by Baudin and Hobbes, which underlined the supreme power of the sovereign and led to notions of the sovereignty of states. Elements of both positivism and naturalism appear in the works of Vattel, 1714 to 1767, a Swiss lawyer. His droit de genre was based on natural law principles, yet was practically oriented. He introduced the doctrine of the equality of states into international law, declaring that a small republic was no less sovereign than the most powerful kingdom, just as a dwarf was as much a man as a giant. By distinguishing between the laws of conscience and laws of action, and stating that only the latter were of practical concern, he minimized the importance of natural law. Ironically, at the same time that positivist thought appeared to demolish the philosophical basis of the law of nature and relegate that theory to history, it re-emerged in a modern guise replete with significance for the future. Natural law gave way to the concept of natural rights. It was an individualistic assertion of political supremacy. The idea of the social contract, that an agreement between individuals predated and justified civil society, emphasized the central role of the individual, and whether such a theory was interpreted pessimistically to demand an absolute sovereign as Hobbes declared, or optimistically to mean a conditional acceptance of authority as Locke maintained, it could not fail to be a revolutionary doctrine. The rights of man constitute the heart of the American and French revolutions and the essence of modern democratic society, page 27. Yet, on the other hand, the doctrine of natural law has been employed to preserve the absoluteness of sovereignty and the sanctity of private possessions. The theory has a reactionary aspect because it could be argued that what was ought to be, since it evolved from the social contract or was divinely ordained, depending upon how secular one construed the law of nature to be. The 19th century. The 18th century was a ferment of intellectual ideas and rationalist philosophies that contributed to the evolution of the doctrine of international law. The 19th century, by contrast, was a practical, expansionist and positivist era. The Congress of Vienna, which marked the conclusion of the Napoleonic Wars, enshrined the new international order which was to be based upon the European balance of power. International law became Eurocentric, the preserve of the civilized, Christian states, into which overseas and foreign nations could enter only with the consent of, and on the conditions laid down by the Western powers. Paradoxically, whilst international law became geographically internationalized through the expansion of the European empires, it became less universalist in conception and more, theoretically as well as practically, a reflection of European values. This theme, the relationship between universalism and particularism, appears time and time again in international law. This century also saw the coming to independence of Latin America and the forging of a distinctive approach to certain elements of international law by the states of that region, especially with regard to, for example, diplomatic asylum and the treatment of foreign enterprises and nationals. There are many other features that mark the 19th century. Democracy and nationalism, both spurred on by the wars of the French Revolution and Empire, spread throughout the continent and changed the essence of international relations. No longer the exclusive concern, page 28, of aristocratic elites, foreign policy characterized both the positive and the negative faces of nationalism. Self-determination emerged to threaten the multinational empires of Central and Eastern Europe, while nationalism reached its peak in the unifications of Germany and Italy and began to exhibit features such as expansionism and doctrines of racial superiority. Democracy brought to the individual political influence and a say in government. It also brought home the realities of responsibility, for wars became the concern of all. Conscription was introduced throughout the continent, and large national armies replaced the small professional forces. The Industrial Revolution mechanized Europe, created the economic dichotomy of capital and labor, and propelled Western influence throughout the world. All these factors created an enormous increase of both public and private international institutions, and international law grew rapidly to accommodate them. The development of trade and communications necessitated greater international cooperation as a matter of practical need. In 1815, the Final Act of Congress of Vienna established the principle of freedom of navigation with regard to international waterways and set up a central commission of the Rhine to regulate its use. In 1856, a commission for the Danube was created, and a number of other European rivers also became the subject of international agreements and arrangements. In 1865, the International Telegraphic Union was established, and in 1874, the Universal Postal Union. European conferences proliferated and contributed greatly to the development of rules governing the waging of war. The International Committee of the Red Cross, founded in 1863, helped promote the series of Geneva Conventions beginning in 1864, dealing with the humanization of conflict, and the Hague Conferences of 1899 and 1907 established the Permanent Court of Arbitration and dealt with the treatment of prisoners and the control of warfare. Numerous other conferences, conventions, and congresses emphasized the expansion of the rules of international law and the close network of international relations. In addition, the academic study of international law within higher education developed with the appointment of professors of the subject and the appearance of specialist textbooks emphasizing the practice of states. Page 29. Positivist theories dominate this century. The proliferation of the powers of states and the increasing sophistication of municipal legislation gave force to the idea that laws were basically commands issuing from a sovereign person or body. Any question of ethics or morality was irrelevant to a discussion of the validity of man-made laws. The approach was transferred onto the international scene and immediately came face to face with the reality of a lack of supreme authority. Since law was ultimately dependent upon the will of the sovereign in national systems, it seemed to follow that international law depended upon the will of the sovereign states. This implied a confusion of the supreme legislator within a state with the state itself, and thus positivism had to accept the metaphysical identity of the state. The state had a life and will of its own, and so was able to dominate international law. This stress on the abstract nature of the state did not appear in all positivist theories, and was a late development. It was the German thinker Hegel who first analyzed and proposed the doctrine of the will of the state. The individual was subordinate to the state because the latter enshrined the wills of all citizens and had evolved into a higher will, and on the external scene the state was sovereign and supreme. Such philosophies led to disturbing results in the 20th century and provoked a reawakening of the law of nature, dormant throughout the 19th century. The growth of international agreements, customs, and regulations induced positivist theories to tackle this problem of international law and the state, and as a result, two schools of thought emerged. The monists claimed there was one fundamental principle which underlay both national and international law. This was variously posited as right or social solidarity, or the rule that agreements must be carried out, pacta sunt servanda. The dualist, more numerous and in more truly positivist frame of mind, emphasized the element of consent. For Triepel, another German theorist, international law and domestic or municipal law existed on separate planes, the former governing international relations, the latter relations between individuals and between the individual and the state. International law was based upon agreements between states, and such agreements included, according to Triepel, both, page 30, treaties and customs, and because it was dictated by the common will of the states, it could not be unilaterally altered. This led to a paradox. Could this common will bind individual states, and, if so, why? It would appear to lead to the conclusion that the will of the sovereign state could give birth to a rule over which it had no control. The state will was not, therefore, supreme, but inferior to a collection of states' wills. Triepel did not discuss these points, but left them open as depending on legal matters. Thus did positivist theories weaken their own positivist outlook by regarding the essence of law as beyond juridical description. The 19th century also saw the publication of numerous works on international law, which emphasized state practice and the importance of the behavior of countries to the development of rules of international law. The 20th century. The First World War marked the close of a dynamic and optimistic century. European empires ruled the world and European ideologies reigned supreme, but the 1914-18 Great War undermined the foundations of European civilization. Self-confidence faded, if slowly. The edifice weakened, and the universally accepted assumptions of progress were increasingly doubted. Self-questioning was the order of the day, and law as well as art reflected this. The most important legacy of the 1919 peace treaty from the point of view of international relations was the creation of the League of Nations. The old anarchaic system had failed, and it was felt that new institutions to preserve and secure peace were necessary. The League consisted of an assembly and an executive council, but was crippled from the start by the absence of the United States and the Soviet Union for most of its life, and remained a basically European organization. While it did have certain minor successes with regard to the maintenance of international order, it failed when confronted with determined aggressors. Japan invaded China in 1931 and 2 years later withdrew from the League. Italy attacked Ethiopia and Germany embarked unhindered, page 31, upon a series of internal and external aggressions. The Soviet Union, in a final gesture, was expelled from the organization in 1939, following its invasion of Finland. Nevertheless, much useful groundwork was achieved by the League in its short existence, and this helped to consolidate the United Nations later on. The Permanent Court of International Justice was set up in 1921 at The Hague and was succeeded in 1946 by the International Court of Justice. The International Labour Organization was established soon after the end of the First World War and still exists today, and many other international institutions were inaugurated or increased their work during this period. Other ideas of international law that first appeared between the wars included the system of mandates, by which colonies of the defeated powers were administered by the Allies for the benefit of their inhabitants, rather than being annexed outright, and the attempt was made to provide a form of minority protection guaranteed by the League. This latter creation was not a great success, but it paved the way for later concern to secure human rights. After the trauma of the Second World War, the League was succeeded in 1946 by the United Nations Organization, which tried to remedy many of the defects of its predecessor. It established its site at New York, reflecting the realities of the shift of power away from Europe, and determined to become a truly universal institution. The advent of decolonization fulfilled this expectation, and the General Assembly of the United Nations currently has 192 member states. Many of the trends which first came to prominence in the 19th century have continued to this day. The vast increase in the number of international agreements and customs, the strengthening of the system of arbitration, and the development of international organizations have established the essence of international law as it exists today. Communist approaches to international law. Classic Marxist theory described law and politics as the means whereby the ruling classes maintain their domination of society. The essence of economic life was the ownership of the means of production, and all, page 32, power flowed from this control. Capital and labor were the opposing thesis, and their mutual antagonism would eventually lead to a revolution out of which a new, non-exploitative form of society would emerge. National states were dominated by the capitalist class and would have to disappear in the reorganizing process. Indeed, the theory was that law and the state would wither away once a new basis for society had been established, and, because classical international law was founded upon the state, it followed that it too would go. However, the reality of power and the existence of the USSR, surrounded by capitalist nations, led to a modification in this approach. The international system of states could not be changed overnight into a socialist order, so a period of transition was inevitable. Nevertheless, basic changes were seen as having been wrought. Professor Tunkin, for example, emphasized that the Russian October Revolution produced a new series of international legal ideas. These, it is noted, can be divided into three basic interconnected groups. A. Principles of socialist internationalism in relations between socialist states. B. Principles of equality and self-determination of nations and peoples, primarily aimed against colonialism. And C. Principles of peaceful coexistence aimed at relations between states with different social systems. We shall briefly look at these concepts in this section, but first, a historical overview is necessary. During the immediate post-revolution period, it was postulated that a transitional phase had commenced. During this time, international law as a method of exploitation would be criticized by the socialist state, but it would still be recognized as a valid system. The two Soviet theorists, Korovin and Pashukinis, were the dominant influences in this phase. This transitional period demanded compromises in that, until the universal victory of the revolution, some forms of economic and technical, page 33, cooperation would be required, since they were fundamental for the existence of the international social order. Pashukinis expressed the view that international law was an interclass law within which two antagonistic class systems would seek accommodation until the victory of the socialist system. Socialism and the Soviet Union could still use the legal institutions developed by and reflective of the capitalist system. However, with the rise of Stalinism and the socialism in one country call, the position hardened. Pashukinis altered his line and recanted. International law was not a form of temporary compromise between capitalist states and the USSR, but rather a means of conducting the class war. The Soviet Union was only bound by those rules of international law which accorded with its purposes. The new approach in the late 1930s was reflected politically in Russia's successful attempt to join the League of Nations and its policy of wooing the Western powers, and legally by the ideas of Vyshinsky. He adopted a more legalistic view of international law and emphasized the Soviet acceptance of such principles as national self-determination, state sovereignty, and the equality of states, but not others. The role of international law did not constitute a single international legal system binding all states. The Soviet Union would act in pursuance of Leninist, Stalinist foreign policy ideals and would not be bound by the rules to which it had not given express consent. The years that followed the Second World War saw a tightening up of Soviet doctrine as the Cold War gathered pace, but with the death of Stalin and the succession of Khrushchev, a thaw set in. In theoretical terms, the law of the transitional stage was replaced by the international law of peaceful coexistence. War was no longer regarded as inevitable between capitalist and socialist countries, and a period of mutual tolerance and cooperation was inaugurated. Tunkin recognized that there was a single system of international law of universal scope rather than different branches covering socialist and capitalist countries, and that international law was founded upon agreements, page 34, between states which are binding upon them. He defined contemporary general international law as the aggregate of norms which are created by an agreement between states of different social systems, reflect the concordant wills of states, and have a generally democratic character, regulate relations between them in the process of struggle and cooperation in the direction of ensuring peace and peaceful coexistence and freedom and independence of peoples, and are secured when necessary by coercion effectuated by states individually or collectively. It is interesting to note the basic elements here, such as the stress on state sovereignty, the recognition of different social systems, and the aim of peaceful coexistence. The role of sanctions in law is emphasized and reflects much of the positivist influence upon Soviet thought. Such preoccupations were also reflected in the definition of international law contained in the leading Soviet textbook by Professor Kozhenikov, and others where it was stated that international law can be defined as the aggregate of rules governing relations between states in the process of their conflict and cooperation, designed to safeguard their peaceful coexistence, expressing the will of the ruling classes of these states and defended in case of need by coercion applied by states individually or collectively. Originally, treaties alone were regarded as proper sources of international law, but custom became accepted as a kind of tacit or implied agreement, with great stress laid upon opinio juris, or the legally binding element of custom. While state practice need not be general to create a custom, its recognition as legal form must be. Peaceful coexistence itself rested upon certain basic concepts, for example, non-intervention in the internal affairs of other states and the sovereignty of states. Any idea of a world authority was condemned as a violation of the latter principle. The doctrine of peaceful coexistence was also held to include such ideas as good neighborliness, international cooperation, and the observance in good faith of international obligations. Page 35. The concept was regarded as based on specific trends of laws of societal development and as a specific form of class struggle between socialism and capitalism, one in which armed conflict is precluded. It was an attempt, in essence, to reiterate the basic concepts of international law in a way that was taken to reflect an ideological trend, but it must be emphasized that the principles themselves have long been accepted by the international community. While Tunkin at first attacked the development of regional systems of international law, he later came round to accepting a socialist law which reflected the special relationship between communist countries. The Soviet interventions in Eastern Europe, particularly in Czechoslovakia in 1968, played a large part in augmenting such views. In the Soviet view, relations between socialist, communist states represented a new, higher type of international relations and socialist international law. Common socio-economic factors and a political community created an objective basis for lasting, friendly relations, whereas, by contrast, international capitalism involved the exploitation of the weak by the strong. The principles of socialist or proletarian internationalism constituted a unified system of international legal principles between countries of the socialist bloc arising by way of custom and treaty. Although the basic principles of respect for state sovereignty, non-interference in internal affairs, and equality of states and peoples existed in general international law, the same principles in socialist international law were made more positive by the lack of economic rivalry and exploitation and by increased cooperation. Accordingly, these principles incorporated not only material obligations not to violate each other's rights, but also the duty to assist each other in enjoying and defending such rights against capitalist threats. The Soviet emphasis on territorial integrity and sovereignty, while designed in practice to protect the socialist states in a predominantly capitalist environment, proved a great attraction to the developing nations of the Third World, anxious too to establish their own national identities and counteract Western financial and cultural influences. Page 36. With the decline of the Cold War and the onset of perestroika, restructuring, in the Soviet Union, a process of re-evaluation in the field of international legal theory took place. The concept of peaceful coexistence was modified, and the notion of class warfare eliminated from the Soviet political lexicon. Global interdependence and the necessity for international cooperation were emphasized, as it was accepted that the tension between capitalism and socialism no longer constituted the major conflict in the contemporary world, and that beneath the former dogmas lay many common interests. The essence of new Soviet thinking was stated to lie in the priority of universal human values and the resolution of global problems, which is directly linked to the growing importance of international law in the world community. It also pointed out that international law had to be universal and not artificially divided into capitalist, socialist, and third world international law systems. Soviet writers and political leaders accepted that activities such as the interventions in Czechoslovakia in 1968 and Afghanistan in 1979 were contrary to international law, while the attempt to create a state based on the rule was seen as requiring the strengthening of the international legal system and the rule of law in international relations. In particular, a renewed emphasis upon the role of the United Nations became evident in Soviet policy. The dissolution of the Soviet Union in 1991 marked the end of the Cold War and the re-emergence of a system of international relations based upon multiple sources of power untrammeled by ideological determinacy. From that point, Russia, as the continuation of the former Soviet Union, albeit in different political and territorial terms, entered into the Western political system and defined its actions in terms of its own national interests, free from principled hostility. The return to statehood of the Baltic states and the independence of the other former republics of the Soviet Union, coupled with the collapse of Yugoslavia, has constituted, page 37, a political upheaval of major significance. The Cold War had imposed a dualistic superstructure upon international relations that had implications for virtually all serious international political disputes and had fettered the operations of the United Nations in particular. Although the Soviet regime had been changing its approach quite significantly, the formal demise of both the communist system and of the state itself altered the nature of the international system, and this has inevitably had consequences for international law. The ending of inexorable superpower confrontation has led to an increase in instability in Europe and emphasized paradoxically both the revitalization and the limitations of the United Nations. While relatively little has previously been known of Chinese attitudes, a few points can be made. Western concepts are regarded primarily as aimed at preserving the dominance of the bourgeois class on the international scene. Soviet views were particularly accepted, but since the late 1950s and the growing estrangement between the two major communist powers, the Chinese colluded that the Russians were interested chiefly in maintaining the status quo and Soviet-American superpower supremacy. The Soviet concept of peaceful coexistence as the mainstay of contemporary international law was treated with particular suspicion and disdain. The Chinese conception of law was, for historical and cultural reasons, very different from that developed in the West. Law never attained the important place in Chinese society that it did in European civilization. A sophisticated bureaucracy labored to attain harmony and equilibrium, and a system of legal rights to protect the individual in the Western sense did not really develop. It was believed that society would be best served by example and established morality, rather than by rules and sanctions. This Confucian philosophy was, however, swept aside after the successful. The Third World. In the evolution of international affairs since the Second World War, one of the most decisive events has been the disintegration of the colonial empires and the birth of scores of new states in the so-called Third World. This has thrust onto the scene states which carry them a legacy of bitterness over their past status, as well as a host of problems relating to. Page 38. Communist Revolution, to be replaced by strict Marxism-Leninism with its emphasis on class warfare. The Chinese seem to have recognized several systems of international law, for example, Western, Socialist and Revisionist, Soviet Union, and to have implied that only with the ultimate spread of socialism would a universal system be possible. International agreements are regarded as the primary source of international law, and China has entered into many treaties and conventions and carried them out as well as other nations. One exception, of course, is China's disavowal of the so-called unequal treaties, whereby Chinese territory was annexed by other powers, in particular the Tsarist Empire in the 19th century. On the whole, international law has been treated as part of international politics and subject to considerations of power and expediency, as well as ideology. Where international rules conform with Chinese policies and interests, then they will be observed. Where they do not, they will be ignored. However, now that the isolationist phase of history is over, relations with other nations established, and its entry into the United Nations secured, China has adopted a more active role in international relations, an approach more in keeping with its rapidly growing economic power. China has now become fully engaged in world politics, and this has led to a legislation of its view of international law, as indeed occurred with the Soviet Union. The Third World. In the evolution of international affairs since the Second World War, one of the most decisive events has been the disintegration of the colonial empires and the birth of scores of new states in the so-called Third World. This has thrust onto the scene states which carry with them a legacy of bitterness over their past status, as well as a host of problems relating to, page 39, their social, economic, and political development. In such circumstances, it was only natural that the structure and doctrines of international law would come under attack. The 19th century development of the law of nations founded upon Eurocentrism and imbued with the values of Christian, urbanized, and expanded Europe did not, understandably enough, reflect the needs and interests of the newly independent states of the mid and late 20th century. It was felt that such rules had encouraged and then reflected their subjugation, and that changes were required. It is basically those ideas of international law that came to fruition in the 19th century that have been so clearly rejected, that is, those principles that enshrine the power and domination of the West. The underlying concepts of international law have not been discarded. On the contrary, the new nations have eagerly embraced the ideas of sovereignty and equality of states, and the principles of non-aggression and non-intervention in their search for security within the bounds of a commonly accepted legal framework. While this new internationalization of international law that has occurred in the last 50 years has destroyed its European-based homogeneity, it has emphasized its universalist scope. The composition of, for example, both the International Court of Justice and the Security Council of the United Nations mirrors such developments. Article 9 of the Statute of the International Court of Justice points out that the main forms of civilization and the principal legal systems of the world must be represented within the court. And there is an arrangement that of the 10 non-permanent seats in the Security Council, 5 should go to Afro-Asian, page 40, states, and 2 to Latin American states, the others going to Europe and other states. The composition of the International Law Commission has also recently been increased and structured upon geographic lines. The influence of the new states has been felt most of all within the General Assembly, where they constitute a majority of the 192 member states. The content and scope of the various resolutions and declarations emanating from the Assembly are proof of their impact and contain a record of their fears, hopes, and concerns. The Declaration of the Granting of Independence to Colonial Countries and the Peoples of 1960, for example, enshrined the right of colonies to obtain their sovereignty with the least possible delay and called for the recognition of the principle of self-determination. This principle, which is discussed elsewhere in this book, is regarded by most authorities as a settled rule of international law, although with undetermined borders. Nevertheless, it symbolizes the rise of post-colonial states and the effect they are having upon the development of international law. Their concern for the recognition of the sovereignty of states is complemented by their support of the United Nations and its Charter, and supplemented by their desire for economic self-determination, or the right of permanent sovereignty over natural resources. This expansion of international law into the field of economics was a major development in the 20th century, and is evidenced in a myriad of ways. For example, by the creation of the General Agreement on Tariffs and Trade, the United Nations Conference on Trade and Development, and the establishment of the International Monetary Fund and World Bank. The interests of the new states of the Third World are often in conflict with those of the industrialized nations. Witness disputes over nationalizations, but it has to be emphasized that, contrary to the many fears expressed in the early years of the decolonization saga, international law has not been discarded nor altered beyond recognition. Its framework has been retained as the new states, too, wish to obtain the benefits of rules such as those governing diplomatic relations and the use of controlled force, while campaigning against rules which run counter to their perceived interests. While the new countries share a common history of foreign dominance and underdevelopment, compounded by an awakening of national, page 41, identity, it has to be recognized that they are not a homogeneous group. Widely differing cultural, social, and economic attitudes and stages of development characterize them, and the rubric of the Third World masks diverse political affiliations. On many issues, the interests of the new states conflict with each other, and this is reflected in the different positions adopted. The states possessing oil and other valuable natural resources are separated from those with few or none, and the states bordering on oceans are to be distinguished from landlocked states. The list of diversity is endless, and variety governs the makeup of the southern hemisphere to a far greater degree than in the north. It is possible that in legal terms, tangible differences in approach may emerge in the future as the passions of decolonization die down and the Western supremacy over international law is further eroded. This trend will also permit a greater understanding of, and greater recourse to, historical traditions and conceptions that predate colonization, and an increasing awareness of their validity for the future development of international law. In the medium term, however, it has to be recognized that with the end of the Cold War and the rapid development of Soviet, then Russian, American cooperation, the axis of dispute is turning from east-west to north-south. This is beginning to manifest itself in a variety of issues ranging from economic law to the law of the sea and human rights, while the impact of modern technology has hardly yet been appreciated. Together with such factors, the development of globalization has put additional stress upon the traditional tension between universalism and particularism. Globalization in the sense of interdependence of a high order of individuals, groups, and corporations, both public and private, across national boundaries, might be seen as the universalization of Western civilization, and thus the triumph of one special particularism. Page 42. On the other hand, particularism, in the guise of cultural relativism, has sometimes been used as a justification for human rights abuses, free from international supervision or criticism. Suggestions for further reading. T. M. Frank, The Power of Legitimacy Among Nations, Oxford, 1990 L. Henkin, International Law, Politics and Values, Dordrecht, 1995. R. Higgins, Problems and Process, Oxford, 1994. A. Nussbaum, A Concise History of the Law of Nations, Revised Edition, New York, 1954. Page 43. International Law Today. The Expanding Legal Scope of International Concern. International law since the middle of the last century has been developing in many directions, as the complexities of life in the modern era have multiplied. For, as already emphasized, law reflects the conditions and cultural traditions of the society within which it operates. the community evolves a certain specific set of values, social, economic, and political, and this stamps its mark on the legal framework which orders life in that environment. Similarly, international law is a product of its environment. It has developed in accordance with the prevailing notions of international relations, and to survive it must be in harmony with the realities of the age. Nevertheless, there is a continuing tension between those rules already established and the constantly evolving forces that seek changes within the system. One of the major problems of international law is to determine when and how to incorporate new standards of behavior and new realities of life into the already existing framework, so that, on the one hand, the law remains relevant and, on the other, the system itself is not too vigorously disrupted. Changes that occur within the international community can be momentous and reverberate throughout the system. For example, the advent of nuclear arms created a status quo in Europe and a balance of terror throughout the world. It currently constitutes a factor of unease as certain states seek to acquire nuclear technology. Another example is the technological capability to mine the oceans, and the consequent questions as to the nature and beneficiaries of exploitation. The rise of international terrorism has posited new challenges to the system as states and international organizations to deal with this phenomenon while retaining, page 44, respect for the sovereignty of states and for human rights. There are several instances of how modern developments demand a constant reappraisal of the structure of international law and its rules. The scope of international law today is immense, from the regulation of space expeditions to the question of the division of the ocean floor, and from the protection of human rights to the management of the international financial system. Its involvement has spread out from the primary concern with the preservation of peace to embrace all the interests of contemporary international life. But the raison d'etre of international law and the determining factor in its composition remains the needs and characteristics of the international political system. Where more than one entity exists within a system, there has to be some conception as to how to deal with other such entities, whether it be on the basis of coexistence or hostility. International law, as it has developed since the 17th century, has adopted the same approach and has in general, though with notable exceptions, eschewed the idea of permanent hostility and enmity. Because the state, while internally supreme, wishes to maintain its sovereignty externally and needs to cultivate other states in an increasingly interdependent world, it must acknowledge the rights of others. This acceptance of rights possessed by all states, something unavoidable in a world where no one can stand alone, leads inevitably to a system to regulate and define such rights and, of course, obligations. And so, one arrives at some form of international legal order, no matter how unsophisticated and how occasionally positively disorderly. The current system developed in the context of European civilization as it progressed, but this has changed. The rise of the United States and the Soviet Union mirrored the decline of Europe, while the process of decolonization also had a considerable impact. More recently, the collapse of the Soviet Empire and the Soviet Union, the rise of India and China as major powers, and the phenomenon of globalization are also impacting deeply upon the system. Faced with radical changes in the structure of power, international law needs to come to terms with new ideas and challenges. Page 45. The Eurocentric character of international law has been gravely weakened in the last 60 years or so, and the opinions, hopes, and needs of other cultures and civilizations are now playing an increasing role in the evolution of world juridical thought. International law reflects first and foremost the basic state-oriented character of world politics, and this essentially because the state became, over time, the primary repository of the organized hopes of peoples, whether for protection or for more expansive aims. Units of formal independence benefiting from equal sovereignty and law and equal possession of the basic attributes of statehood have succeeded in creating a system enshrining such values. Examples that could be noted here include non-intervention in internal affairs, territorial integrity, non-use of force, and equality of voting in the United Nations General Assembly. However, in addition to this, many factors cut across state borders and create a tension in world politics, such as inadequate economic relationships, international concern for human rights, and the rise in new technological forces. State policies and balances of power, both international and regional, are a necessary framework within which international law operates, as indeed are domestic political conditions and tensions. Law mirrors the concern of forces within states and between states. It is also important to realize that states need law in order to seek and attain certain goals, whether these be economic well-being, survival and security, or ideological advancement. The system therefore has to be certain enough for such goals to be ascertainable, and flexible enough to permit change when this becomes necessary due to the confluence of forces demanding it. International law, however, has not just expanded horizontally to embrace the new states which have been established since the end of the Second World War. It has extended itself to include individuals, groups, and international organizations, both private and public, within its scope. It has also moved into new fields covering such issues as international trade, problems of environmental protection, human rights, and outer space exploration. Page 46. The growth of positivism in the 19th century had the effect of focusing the concerns of international law upon sovereign states. They alone were the subjects of international law and were to be contrasted with the status of non-independent states and individuals as objects of international law. They alone created the law, and restrictions upon their independence could not be presumed. But the gradual sophistication of positivist doctrine, combined with the advent of new approaches to the whole system of international relations, has broken down this exclusive emphasis and extended the roles played by non-state entities, such as individuals, multinational firms, and international institutions. It was, of course, long recognized that individuals were entitled to the benefits of international law, but it is only recently that they have been able to act directly rather than rely upon their national states. The Nuremberg and Tokyo tribunals set up by the victorious Allies after the close of the Second World War were a vital part of this process. Many of those accused were found guilty of crimes against humanity and against peace, and were punished accordingly. It was a recognition of individual responsibility under international law, without the usual interposition of the state, and has been reinforced with the establishment of the Yugoslav and Rwanda war crimes tribunals in the mid-1990s and the International Criminal Court in 1998. Similarly, the 1948 Genocide Convention provided for the punishment of offenders after conviction by national courts or by an international criminal tribunal. The developing concern with human rights is another aspect of this move towards increasing the role of the individual in international law. The Universal Declaration of Human Rights, adopted by the United Nations in 1948, lists a series of political and social rights, although it is only a guideline and not legally binding as such. The European Convention for the Protection of Human Rights and Fundamental Freedoms, signed in 1950, and the International Covenant on Human Rights in 1966 are of a different nature and binding upon the signatories. In an effort to function satisfactorily, various bodies of a supervisory and implementational nature were established. Within the European Union, individuals and corporations have certain rights of direct appeal to the European Court of Justice against decisions of the various Union institutions. In addition, individuals may appear before certain international tribunals. Nevertheless, the whole subject has been highly controversial, with some writers, for example Soviet theorists prior, page 47, to perestroika, denying that individuals may have rights as distinct from duties under international law, but it is indicative of the trend away from the exclusivity of the state. Together with the evolution of individual human rights, the rise of international organizations marks perhaps the key distinguishing feature of modern international law. In fact, international law cannot in the temporary era be understood without reference to the growth in number and influence of such intergovernmental institutions, and of these the most important by far is the United Nations. The UN comprises the vast majority of states. There are currently 192 member states, and that alone constitutes a political factor of high importance in the process of diplomatic relations and negotiations, and indeed facilitates international cooperation and norm creation. Further, of course, the existence of the Security Council as an executive organ with powers to adopt resolutions in certain circumstances that are binding upon all member states is unique in the history of international relations. International organizations have now been accepted as possessing rights and duties of their own and a distinctive legal personality. The International Court of Justice in 1949 delivered an advisory opinion in which it stated that the United Nations was a subject of international law and could enforce its rights by bringing international claims in this case against Israel following the assassination of Count Bernadotte, a United Nations official. Such a ruling can be applied to embrace other international institutions, like the International Labour Organization and the Food and Agriculture Organization, which each have a judicial character of their own. Thus, while states remain the primary subjects of international law, they are now joined by other non-state entities, whose importance is likely to grow even further in the future. The growth of regional organizations should also be noted at this stage. Many of these were created for reasons of military security, for example NATO and the opposing Warsaw Pact organizations, others as an expression of regional and cultural identity, such as the Organization of African Unity, now the African Union, and the Organization of American States. In a class of its own is the European Union, which has gone far down the road of economic coordination and standardization and has a range of, page 48, common institutions serviced by a growing bureaucracy stationed primarily at Brussels. Such regional organizations have added to the developing sophistication of international law by the insertion of regional international law subsystems within the universal framework and the consequent evolution of rules that bind only member states. The range of topics covered by international law has expanded hand in hand with the upsurge in difficulties faced and the proliferation in the number of participants within the system. It is no longer exclusively concerned with issues relating to the territory or jurisdiction of states narrowly understood, but is beginning to take into account the specialized problems of contemporary society. Many of these have already been referred to, such as the vital field of human rights, the growth of an international economic law covering financial and development matters, concern with environmental despoliation, the space exploration effort, and the exploitation of the resources of the oceans and deep seabed. One can mention also provisions relating to the bureaucracy of international institutions, international administrative law, international labor standards, health regulations, and communications controls. Many of these trends may be seen as failing within, or rather reflecting, the phenomenon of globalization, a term which encompasses the inexorable movement to greater interdependence founded upon economic, communications, and cultural bases and operating quite independently of national regulation. This in, page 49, turn stimulates disputes of an almost ideological nature concerning, for example, the relationship between free trade and environmental protection. To this may be added the pressures of democracy and human rights, both operating to some extent as countervailing influences to the classical emphasis upon the territorial sovereignty and jurisdiction of states. Modern theories and interpretations. At this point, some modern theories as to the nature and role of international law will be briefly noted. Positive law and natural law. Throughout the history of thought, there has been a complex relationship between idealism and realism, between the way things ought to be and the way things are, and the debate as to whether legal philosophy should incorporate ethical standards or confine itself to an analysis of the law as it stands is a vital one that continues today. The positivist school, which developed so rapidly in the pragmatic, optimistic world of the 19th century, declared that law as it exists should be analyzed empirically, shorn of all ethical elements. Moral aspirations were all well and good, but had no part in legal science. Man-made law must be examined as such, and the metaphysical speculations of natural law rejected because what counted were the practical realities, not general principles which were imprecise and vague, not to say ambiguous. This kind of approach to law in society reached its climax with Kelsen's pure theory of law. Kelsen defined law solely in terms of itself and eschewed any element of justice, which was rather to be considered within the discipline of political science. Politics, sociology, and history were all, page 50, excised from the pure theory which sought to construct a logical unified structure based on a formal appraisal. Law was to be regarded as a normative science, that is, consisting of rules which lay down patterns of behavior. Such rules or norms depend for their legal validity on a prior norm, and this process continues until one reaches what is termed the basic norm of the whole system. This basic norm is the foundation of the legal edifice, because rules which can be related back to it therefore become legal rules. To give a simple example, a court order empowering an official to enforce a fine is valid if the court had that power, which depends on an act of Parliament establishing the court. A rule becomes a legal rule if it is in accordance with a previous and higher legal rule, and so on. Layer builds upon layer, and the foundation of it all is the basic norm. The weakness of Kelsen's pure system lies primarily in the concept of the basic norm, for it relies for its existence upon non-legal issues. In fact, it is a political concept, and in the United Kingdom, it would probably be the principle of the supremacy of Parliament. This logical, structured system of validity founded upon an extra-legal concept encounters difficulty when related to international law. For Kelsen, international law is a primitive legal order because of its lack of strong legislative, judicial, and enforcement organs, and its consequent resemblance to a pre-state society. It is accordingly characterized by the use of self-help. The principles of international law are valid if they can be traced back to the basic norm of the system, which is hierarchical, in the same sense as a national legal system. For Kelsen, the basic norm is the rule that identifies custom as the source of law, or stipulates that the states ought to behave as they customarily behaved. One of the prime rules of this category is pacta sunt servanda, declaring that agreements must be carried out in good faith, and upon that rule is founded the second stage within the international legal order. This second stage consists of the network of norms created by international treaties and conventions.